Assalamualaikum warahmatullahi wabarakatuh. Welcome to my video. My name is Muhammad Ikmalluhur Purnawan. I am from Fakultas Hukum Universitas Pembangunan Nasional Veteran Jakarta dengan NIM 231061148. So what I'm gonna do today is I want to explain to you all guys about this employment contract. Before we started, I want to say a, a bit about what I've know about employment contract. Employment contract is obviously a contract between two parties. It usually um, there are employee and employer in this um, contract. The employer is who give the job, and an employee is who work the job. So the contract is like to like validate or legalize the agreement between these two parties. Like if the employee want to terminate this contract, it's written all in this contract. Or if there's compensation, if the employee like insurance or anything, it could be written in this contract, in the employment contract. So I will start from this first page. It stated in this contract, this agreement made on the blank day of the blank month of the year blank between the employer and the employee. So um, the day and the month and the year that stated in this contract is like to um, validate when are this employment uh, is like uh, made when was this contract made. So like you could write any date or month according to the date you signing this contract. So the contract is obviously between an employer and an employee. Okay, so we move. Whereas the employee and the employer wish to enter into an employment agreement governing the terms and conditions of employment. This agreement witnessed that in consideration of the premises and mutual covenants and agreements hereinafter, contained is hereby acknowledged and agreed by and between these parties hereto as follows. So there's so many like agreement in this contract. The first agreement is term of employment. It stated that the employment of the employee shall commence from the date hereof and continue for an indefinite term until terminated in accordance with the provisions of this agreement. So um, the employee will start working from the date and continue for an indefinite term until terminated with an agreement. And the next part is probation. The parties here to agree that this initial 6-month period of disagreement is probationary. So it's like not permanent. It's like probationary for only 6 months. The employer shall have an opportunity to assess the performance, attitude, skills, and other employment-related attributes and the characteristics of the employee. So within this 6 month, the employer could like assess, could like judge the work job that work ethic that this employee have done, and either party may terminate the employment relationship at any time. So um, the employment could like terminate, the employer could like terminate, or like the employer like could also terminate this contract anytime during the initial 6 month period with advance notice of 7 days with justifiable reason, in which case there will be no continuing obligations of the parties to each other, financial or otherwise. The next part is about compensation and benefits. In consideration of the services to be provided here by him hereunder, the employee during the term of his employment shall be paid a basic salary of number a month a week, less applicable statutory deductions. In addition, the employee is entitled to receive benefits in accordance with the employer's standard benefit package as amended from time to time. So it basically talk about wages, salary. Okay. Number four, the duties and responsibilities. The employee shall be employed in the capacity of blank to the current duties and responsibilities of which are set out in Annexure A, annexed hereto and forming part of this agreement. These duties and responsibilities may be amended from time to time in the sole discretion of the employer, subject to formal notification of same being provided to the employee. Number five, termination of employment subsequent to completion of the probationary term, which is stated back in number 2, I think, probationary of 6 months, referred to in paragraph 2 herein, the employer may terminate the employment of the employee at any time in within this 6 months. For just cause at a common law, in which case the employee is not entitled to any advance notice of termination or compensation in lieu of notice, the employee and employer may terminate their employment at any time by providing at least 7 days notice for probationer and 1 month advance notice for their intention to terminate the contract of employment or payment in lieu thereof. Then entitlements and termination of services will be governed by the Labor and Employment Act 2007 and its regulations and laws of the land. And we're now talking about confidentiality. The employee acknowledges that in the course of performing and fulfilling his duties hereunder, he may have access to and be entrusted with confidential information concerning the present and contemplated financial status and activities of the employer. So, basically, like the employee could know every information of the employer. The disclosure of any of which confidential information to competitors of the employer will be highly detrimental to in the interest of the employer. The employee further acknowledges that and agrees that the right to maintain the confidentiality of such information constitute a proprietary right which the employer is entitled to protect. Accordingly, the employee covenants and agrees with the employer that he will not, during the continuance of this agreement, disclose any of such confidential information to any person, firm, or corporation, nor shall he use same, except as required in the normal course of his engagement hereunder, and thereafter he shall not disclose or make use of the same. Number 7, assignment, transfer of contract of employment. This agreement shall be signed by the employer or an successor employer. So if there's any another employer, successor employer, and be binding upon the successor employer with the consent of the employee. The employer shall ensure that the successor employer shall continue the provisions of this agreement. So if there's any successor in this company, have to like continue this agreement as if it were the original party of the first part. This agreement may not be assigned by the employee. Severability. Each paragraph of this agreement shall be and remain separate from and independent of and severable from all and any other paragraphs herein except where otherwise indicated by the context of the agreement. The decision or declaration that one or more of the paragraphs are null and void shall have no effect on the remaining paragraphs of this agreement. Okay, here is the working conditions. It is very fundamental for the employee to know this working condition. For example, um, if a she was an employee, they have to know like their maternity leave. If she's pregnant, they have to leave provided must at the minimum be provided as prescribed by the regulations on leave. Or like uh, on public holidays, uh, they could like um, change the days, excluding other leave entitlements, casual, annual, medical, etc. Both parties may agree to substitute public holiday with another public holiday. Okay, here is the working conditions for the employee to like know. Notice, any notice required to be given hereunder shall be deemed to have been properly given if delivered personally or sent by prepaid registered mail as follows. To the employee address, to the employer address, and if sent by registered mail shall be deemed to have been received on the 5 working days of uninterrupted postal service following the date of mailing. Either party may have changed its address for notice at any time by giving notice to the other party pursuant to the provisions of this agreement. Interpretation of agreement. The validity, interpretation, construction, and performance of this agreement shall be governed by the Labor and Employment Act 2017 and its regulations. So the employer could not like make any breach of this contract. Like they have to know the Labor and Employment Act and the regulation. This agreement shall be interpreted and with all necessary changes in gender and in number as the context may require, and shall ensure to the benefit of and be binding upon the respective successors and assigns of the parties hereto. In witness whereof the parties here to have caused this agreement to be executed as of blank day, blank month, blank year, and shall each retain a copy of the agreement in original. So yeah, that's all about this employment contract. In conclusion, this contract is, yeah, what I've said earlier. It's um, all about agreeing the like um, the situation between employer and employee, which that uh, employee have to know uh, the terms if they work on the employer uh, like business or something. So after this agreement is like valid, they could not make any breach of this agreement. So um, yeah, it's all like it's already valid if they resign this contract. So um, that's for me. Sorry for any interpreted or like I I make any mistake. I'm sorry. Thank you for your attention. Wassalamualaikum warahmatullahi wabarakatuh.